In the landmark 1935 case of Humphrey's executor, the Supreme Court ruled that Congress could place limits on the president's power to fire some executive officials. This ruling is significant in part because it allows Congress to establish what are called independent regulatory agencies. These agencies typically consist of a 5-member board with staggered and fixed terms, so that no one president can appoint every member. Presidents can only fire members of these agencies for cause, that is, if they have demonstrated incompetence, malfeasance, or dereliction of duty. These agencies are intended to be independent of political pressure, including pressure from the president. There are more than a dozen of these agencies, including the Federal Aviation Administration, the Securities and Exchange Commission, the Food and Drug Administration, and so on. In 1986, the Supreme Court issued another ruling that further defined and limited the president's power to fire executive branch officials. The case had its roots in the Saturday Night Massacre of 1973. The Attorney General is ultimately responsible for investigating violations of federal law. But because the Attorney General can be fired by the President at will, independent investigations of the President or his officials can be hard to achieve. Usually this problem is addressed by the Attorney General appointing an independent counsel or special counsel for a limited period of time. For example, both Joe Biden and Donald Trump were recently investigated by special prosecutors for their mishandling of classified documents after they had left office. In 1974, Richard Nixon's Attorney General appointed an independent counsel, Archibald Cox, to investigate the Watergate scandal. At the time, the president did not have the power to fire the independent counsel. Only the Attorney General could do so. After Cox demanded that Nixon turn over the audio tapes from his secret taping recording device in the Oval Office, Nixon ordered his Attorney General, Elliot Richardson, to fire Cox. This put Richardson in a difficult position. During his confirmation hearing, he had promised the U.S. Senate that he wouldn't fire a special prosecutor unless they had done something wrong, which Cox clearly had not. Therefore, on Saturday, October 20th, 1973, Richardson resigned rather than comply with Nixon's order.
Deputy Attorney General William Ruckelshaus then became the acting Attorney General. Nixon ordered Ruckelshaus to fire Cox, but Ruckelshaus also refused and resigned on the same day. The Solicitor General, Robert Bork, then became the acting Attorney General. Nixon ordered Bork to fire Cox, and he did. All of this happened on the same day in October 1973, and it was a major scandal. Partially in response, Congress passed the Independent Counsel Act in 1978. It established a complicated procedure for appointing independent counsels. More relevant to our discussion, it wrote into law the limitation that only attorneys general could fire independent counsels, and that they could only do so for good cause. Several years later, Theodore Olson, a Bush administration official who was under investigation by an independent counsel, took his case to the Supreme Court, arguing that the Independent Counsel Act was unconstitutional. He argued that because prosecution is entirely an executive function, the chief executive can't be limited in his power to fire the independent counsel. In a nearly unanimous 8-1 decision, the court rejected that argument and upheld the law. While they agreed that the law limited the president's executive power, the infringement was minor. This was an important decision because it allowed the practice of independent investigations into wrongdoing by the president and other administration officials could continue. Taken together, Humphrey v. U.S. and Morrison v. Olson clearly established the principle that Congress can place limits on the president's ability to fire some officials for purely political reasons, giving those officials a large degree of independence. These principles have been clearly established for several decades, until recently. Morrison v. Olson was nearly unanimous. There was only one dissent, written by Justice Antonin Scalia. But over time, Scalia's dissent has become increasingly important. Scalia's dissent formulated what has come to be known as the Unitary executive theory. Scalia essentially argued that a president's executive power cannot be limited in any way whatsoever. He wrote, quote, "The executive power shall be vested in a president of the United States," end quote. But this does not mean some of the executive power, but all of the executive power. Therefore, the president should have the power to fire any executive official at any time for any reason. Under this logic, all independent regulatory agencies would be unconstitutional.
This was a fringe theory back in 1986 when Morrison versus Olson was decided. Only one justice endorsed it. But over the past 4 decades, conservative judges have increasingly embraced it. As the Supreme Court has become more conservative, it has issued a series of technical but important decisions giving the president more power to fire executive officials. While it has not yet technically overruled either Humphrey's executor or Morrison versus Olson, it may be about to do so. Soon after his second term began in 2025, in violation of the law, Donald Trump fired members of 2 independent regulatory agencies merely because they disagreed with him. Those employees filed an appeal. In May 2025, the Supreme Court issued a ruling upholding the firings. Although it stressed that its ruling was temporary and might be reversed later, this was a 6-3 decision, with all 6 of the court's conservatives voting in favor of President Trump and all 3 of the liberals voting against him. The power to fire executive officials at will, even independent counsel and members of independent regulatory agencies, would be a dramatic expansion of presidential power, and it's one that might easily be abused by a lawless president. While presidents have the power to fire the head of the FBI, they normally do not interfere with them for political reasons. Early in his first term, Donald Trump fired FBI Director James Comey because Comey would only pledge loyalty to the Constitution rather than to Donald Trump personally. One wonders how he might use an unlimited firing power in the future.